All right, everybody. Thank you for coming. As you make your way to your seats and grab some more food and drink, I apologize for starting a little bit later. I was told that the traffic was really bad getting here from almost all directions, and I guess there's an issue with the train, so we're waiting on some people to come, so we didn't want to start too early. So because we're starting later, I promise we'll end by 9. Is that okay? Yeah, it is. It's really great to see so many friends, old and new here, and let's wait a few more minutes till everybody gets situated. Yeah, what? Dinner? No. Thank you. So today's actually, and tonight's pretty special for Bridgeford. You know, there's so many friends of Bridgeford in the room that have supported us from the very beginning, and this launch of the Philadelphia office is so exciting for us, and in many ways, it's coming home. I grew up in South Jersey, and Bridgeford as a concept began in Pennsylvania, in central Pennsylvania. And so as we begin, I think a really great conversation around some timely issues, let's do a quick round of applause, because we're so happy to be here, and thank you all. So very briefly, you know, back in 2011, we had this idea for kind of a paradigm shift concept of a trust company. You know, we were all familiar with the Bank of New York Mellon model and the PNC model and the bundling approach. And myself and my co-founders thought that there was sort of a different way to do it. And we thought that there was a new emerging paradigm in this directed trust, independent trust company space. And that independence word is something that we're going to come back to towards the end of the night. But the idea it was to create a trust company that was friendly to investment advisors, that was friendly to the rest of the industry, and was able to play nice in the sandbox. And so the idea was hatched actually in central Pennsylvania, and we got very excited about big idea concepts: asset protection, privacy, tax planning, all things. Many things you can't do here in Pennsylvania with Pennsylvania trust law or New Jersey. Delaware, of course, is the leader, has been the leader for years, but it's not only the best jurisdiction or one of the best jurisdictions. And we became excited about South Dakota. And so we were crazy enough, a couple of people, one lawyer and a couple of CPAs from Pennsylvania, to select South Dakota as our jurisdiction. And tonight isn't necessarily a commercial for South Dakota. It's really a promotion of modern trust law and a celebration of modern trust law altogether, which is how Bridgeford has gotten to where we are. So Bridgeford, launched our charter in 2012, and it took a big chance with no revenue, right, Kurt? For the last 10 years. No, I'm joking. We have some revenue now, and we really took a chance on truly a big idea. And my partners were a bit more entrepreneurial than I was, and I always say I was a lot taller and better looking when we started this company. That was a joke. I was never tall and better looking, I can promise you. But the reality, though, is that from that sort of fateful time in 2011, 2012, we were cocky enough to believe we were going to reinvent what was going on in the trust space, at least in the Northeast, and that took a while to catch attention in the Northeast. We found that we were resonating better in New York City and Philadelphia. Firms like Morgan Lewis took an interest in us early and what we were doing, and I'm going to introduce our friends there in a minute. But we really kind of hit a nerve and found that this conversation was really, really important all over the country. When I say conversation, I'm talking about an independent trust company, no conflict of interest, and really being able to collaborate instead of compete in the marketplace. So we evolved in 2018, and we were cocky enough to think that we should buy another trust company, and we did. We bought a smaller trust company in South Dakota, which was founded back in 1992 and was arguably the first private trust company. The reason why I share that with you is because right around that time is when Bridgeford really hit a sort of a tipping point. And so you fast forward to today. Of course, we merged that company in, and we are now Bridgeford Trust Company with 2 offices in South Dakota, 10 trust officers as of today, because we just promoted 2 trust officers, many of which have law degrees. We're trending towards $15 billion in assets under administration. We have offices in Miami, rep offices in Miami. We do not administer trust there. Same thing in California. And now, Pennsylvania, 1601 Market Street, which is particularly important, and it's a milestone for not only me, but also Kurt Tremarchi, my co-founder, which I'll introduce in a minute, because we both had offices in Philadelphia within blocks of now what we have in our Bridgeford office. So it's very exciting for us. And where we're going is very, very exciting. And having you all here is very humbling because there's so many faces in the crowd that I know took a chance on an early Bridgeford and listened to a story that we were trying to tell, and the story was always the same. We wanted to be part of a new conversation. We wanted to be part of the dialogue that was happening in our industry. And as I said, it was less about selling South Dakota or selling trusts. It was about being part of the evolving trust industry, which I think we can all agree has changed so dramatically. I mean, some of the things, all the things we're going to talk about today didn't exist when I was in law school. And Dan, I'm a lot older than you, so don't point that out. So, a couple of things I want to say before I introduce an amazing panel of great supporters of ours over the years. The core of Bridgeford is here. I've already mentioned Kurt Tremarchi. He's one of our co-founders. Truth be told, this crazy idea of a trust company started in Lancaster County over multiple conversations over a couple glasses of vodka. It cost several bars. Chris Ginder from Lancaster, he knows those bars because you used to see us back in 2011. You said, "What are you doing?" I'm like, "Well, we're starting a company." And then we went home and forgot what we were doing. But that's really how it began. So Kurt is on our board. He's chair of our finance committee. He's been one of my closest friends for many, many years. And Kurt, thanks for being here. Other part of the core of Bridgeford is Sherry Lapp, who's standing back there. She greeted you all coming in. Started out working with McKonly Asbury, who is also a supporter of Bridgeford, and I'll get to that in a minute. And she's evolved and grown into our director of operations, very much the backbone of the organization, and somebody I'm very proud of, and can say that she's part of the DNA. As is Melissa Roberson in the back. If you look around and all the organization and all the details, and you see a lot of stuff on the website comes from her brain, her marketing brain, and she too was part of the DNA from the very beginning and with Bridgeford before we even had a name of Bridgeford. And I also want to just mention Mike Hoffner. Mike Hoffner is the managing partner of a firm called McKonly Asbury. Some of you would know, same firm that Kurt was managing partner. And Mike Hoffner is also on our board. He's part of the core and DNA of the company because he was part of the partner group at McKonly Asbury at the time who agreed to join in this crazy adventure and come up with some of the cash that we needed, which he thinks we're going to pay back someday. I don't know. Again, that was a joke too, you guys. Come on. You haven't had enough to drink yet. The more you drink, the funnier I am. So if you can get a couple more drinks, that'd be awesome. But no, Mike is a success story, and so is McKonly Asbury, because not only is Bridgeford now here in Philadelphia, but we're here because McKonly Asbury is now here in Philadelphia. So I'd like to do a quick round of applause, but before I'll tell you who they are. They are an industry-leading accounting firm, homegrown out of central Pennsylvania, always occupied a special niche in what they do. They were able to connect and partner, collaborate, and ultimately merge and acquire your firm. Morris Cohen. Sorry, I forgot the name for a second. And so we'll get to that in a second. But a quick round of applause for McKonly Asbury. There's a lot of McKonly Asbury folks here. They also have landed in Philadelphia and also are going to have an impact in this marketplace. So Mike, I said, is on our board. He's also does our audit and compliance stuff. So really, I cause him a lot of trouble and a lot of headaches. So that's he keeps us out of trouble. So again, thank you for being here. What we want to do tonight now is shift into conversations about big ideas and the things that we're really passionate about. In addition to our growth, we're really excited about the things that we're able to do because of our trust charter and because of the amazing professionals that we have been working with. So I'll start with my immediate left. Christina Fornes is an attorney at Morgan Lewis. Has been there for what, 20 years plus? Is that my close? 33. Okay, I didn't want 33 years. Does not even look like she's 33 years old. But chairs the Trust and Estates Group and the private client group for Morgan Lewis, has for many years, and has a tremendous reputation in the marketplace all over the tri-state area, working with some of the largest families in the region and really around the world. And I know you took an early interest in Bridgeford, and we can't thank you enough. Dan Cooper, a lot of you know, a brilliant legal mind. He, like Christina and myself and those of us at Bridgeford, loves the big idea conversations. And I'm not talking about tax evasion or secrecy or doing anything nefarious. We're talking about playing by the rules. And as I always like to say, whoever knows the game, the rules of the game of chess the best usually wins. And it's the same thing in our industry. And Dan knows the rules really well. In addition to being a Pennsylvania attorney, he actually waved into South Dakota as an attorney. So he's one of 2 attorneys in South Dakota. Kidding, there's more attorneys in South Dakota. So Dan Cooper is going to be presenting. He also took an early chance on a very young Bridgeford and a David Warren that was learning his way around how to manage a trust company. So thank you, Dan. My new friend, Michael, a lot of you know Michael. He has been in this space in Philadelphia for many, many years, Michael Bonifater, and he actually ran and was a principal in the firm I mentioned a moment ago, Morris Cohn. He now is the managing director of the McKonly Asbury office here in Philadelphia. And so we have a really interesting perspective on some of these topics because, I have the sort of the trust company administrative perspective. We're talking about things from a tax perspective, and then we have, of course, Dan and Christina getting into some case law. And they have about 16 cases they're going to go through in meticulous detail. What do you think? Good idea? But there's really nothing I'm going to say that's going to make you guys laugh tonight. I'm going to keep trying, though. So here's a quick agenda. I've already done welcome and introductions. Thank you all for being here. The idea is unsettled times. We are in unsettled times, and that only heightens and amplifies the need for well-settled trust. I mean, we just came through an incredibly contentious presidential election. There are lots of changes that are coming. Some of you may like, some of you may not like, but regardless, change is coming. And we need to think about how to prepare for that, and that's, I think, what we all do best on stage here, is trying to plan for what's next. Talk about some tax planning that we can do, practical tax planning. I know there's concerns of things that may happen in 2025 or not. Either way, it's good to be prudent. It's good to know that really just by selecting a proper trust jurisdiction, there's some really compelling ways to legally and properly and appropriately save your clients money on taxes, and we're really excited about the kinds of things that Michael's going to talk a little bit about. And then we're going to transition to talking about strategies. So Dan and Christina are going to talk about more granular strategies, some of which you may have heard, some of which you may not have heard, but they're just big ideas that really take further advantage of this jurisdiction selection and how important it is. And again, it's not so much about South Dakota, it's just as much about Delaware and Nevada and Alaska to some degree, but what it's not about in many cases is Pennsylvania or South Dakota or New Jersey, California, some of these high tax jurisdictions. And it's just very simple, Steve. It's just very simple to make the right decision there. And then I'm going to get into modern trust laws and what it is about modern trust law that takes what these experts are going to talk about and make it palatable for your clients. Because what is the big concern a lot of clients have? Yeah, I want tax mitigation, I want asset protection, I want privacy, but what do they not want? They don't want to lose control, right? So modern trust law delivers direction and control to families in a way that certainly did not exist when I was in law school. So with that, thank you all again for being here. I'm going to ask Michael to kind of lead us with, well, actually, before we get there, sorry. And two things I wanted to mention. One, highly interactive. We have very, very smart people in this room. And so if you have an opinion, if you disagree with them, not me, you have to agree with me, but if you disagree with them, feel free to tell them. And tell them loudly, because this is being recorded. So we want to make sure that if you have something wrong, that you think they said something wrong, please let them know. Just kidding. It is being recorded, though, so don't use any bad language, okay? But, look, the reality is, here's what makes things unsettled for us. The push for transparency, we're all aware of the CTA. We've talked about it too much, but I guess maybe not enough because people don't know about it. That is an issue that we can deal with trust planning because some folks are very concerned about privacy right now. The presidential election, we've already talked about it. And there's probably going to be a lot of political and social unrest, unfortunately. How do we plan for that? How do we prepare for that? How do we think about that? Look, there's still global tension and taxation uncertainty, geopolitical tension and taxation uncertainty. Again, making trust planning so much more compelling. Safety concerns for wealthy families, it's mostly international, but also domestically, especially as there's such a push for transparency. Very wealthy families are very worried about what happens if their information becomes public, which is the big concern around the CTA that a lot of families have. Asset protection, I can say, and I'll let Dan and Christina and others speak to it, but I can tell you, Bridgeford, that's one of the first questions we get is what is this asset protection and how do we get it? And there are ways to do it using proper trust planning to get proper protection. Data leaks, we all know data leaks. It creates an unsettled nature for how we handle things and how we deal with that. And I'll say, I think our industry is a bit under attack. We won't get into it too much, but there's been data leaks that have led to commentators around the country and around the world, particularly The Guardian, issuing scathing attacks on South Dakota and Delaware and jurisdictions that are favorable for tax planning and asset protection, and somehow it's suggesting that we're nefarious because because we know the rules of the game better. Sometimes suggesting that people like Dan Cooper and Christina are somehow engaging in tax evasion or advising on tax evasion or secrecy, and that's not at all what we're doing. And in my view, I think we have an obligation to do this, and we're going to end on that conversation and get some debate going in terms of, do we have a duty? But I don't think we should be apologizing for the work we do. You know, I mean, Jennifer is in the audience that I know from Miami. She does the same kind of work, and particularly in the international space, I know we all have been attacked for the work that we do, and we're not doing anything wrong, and I think what we're doing is virtuous, and I stand firm on that. So we'll kind of go from here, then take it to Michael. I'm a big U2 fan, some of you know, and this quote really resonated with me when COVID came out. And I love it, because it says, you know, don't worry, it's all going to be all right. Uncertainty can be a guiding light. Unequivocally, we're in uncertain time, perhaps unprecedented uncertain times. And I think not only can uncertainty be a guiding light, but I think it's a call to action. And that's what we've been talking about. There's an unbelievable call to action. Now's not the time to freeze, put your head in the sand, and conjecture about what might happen, because there are things you can do to address anything that might happen in the next year and the coming years. So with that, Michael, I'll let you take it away.
Thank you, Dave. We've joined the McKonly family about 10 months ago now, 11 months, January, and as such, we inherited, I guess, Bridgeford with that combination. And
you say that with so much enthusiasm.
No, I think it's wonderful. Thank you very much. We've had some interesting conversations. So basically, we were talking about trust here, and I think some people, that's kind of a scary word sometimes, and trust can be very complex, and this is a fairly complex topic on the income tax side and the asset protection, et cetera. So I figured I want to start a little bit with the Trust for Dummies 101. So there's basically three types of trusts that, you know, commonly we look at. One's a grantor trust, and basically a grantor trust is all the income gets taxed to the person who set up the trust. And then there's a simple trust, which basically says all the income gets taxed to the person who is the income beneficiary, except maybe capital gains, but that also can change depending on the trust document. And then there's complex trust, which says the trust gets taxed for anything that does not get distributed. So if we retain the income inside the trust is the one paying the tax and not the grantor or the beneficiaries. So this conversation we're having basically is about complex trust. It doesn't work with simple trust. It doesn't work with grantor trust. It's basically complex trust where we're retaining the income. And the goal is to retain the income in the trust and not pay any state income taxes. So from an income tax perspective, we're trying to avoid, I won't say evade, but avoid state income taxes. Not federal. These trusts will still pay federal income taxes, but the key is to avoid state income taxes. So the question is, well, that sounds really great, and how do we actually do that? So Pennsylvania, we'll focus a little bit on Pennsylvania law. I always find this very confusing, even from a person whose perspective who does this a lot. So basically, a Pennsylvania law taxes Pennsylvania resident trusts. And a resident trust is created in whole or part by property transferred for a trust by a person who at the time of such creation transfer was a PA resident. So if you read the statute and you read the definition, you would say, I set up a trust in Pennsylvania, how could I avoid Pennsylvania income tax on that since it's a resident trust? So the way to kind of do that is basically we set up a PA trust, all right? So it's a resident trust. I set up a trust as a resident PA. I have a PA resident trust, taxable in PA at the moment. I set it up, though, in a jurisdiction that doesn't have income tax for a trust. That could be, in this case, we'll use South Dakota. Coincidentally, we'll say South Dakota. South Dakota has no income tax for a trust. So now I have a resident trust. I set it up in South Dakota without any income tax, and the beneficiary of my trust is Jeremy's beneficiary is a PA resident. So now I have a PA trust set up by a PA resident with a PA resident beneficiary. And of course, Pennsylvania will say, well, that's now taxable. But is it? That's the key question. Is that trust taxable? Of course, we wouldn't be here talking about it if it was. How do we make it not taxable? Or what law says it's not taxable? And basically, I think we've slipped a slide with the different court cases. So there's been a bunch of court cases. We'll get back to the Dynasty Trust in a second. There's a bunch of court cases on this issue. The key court case in Pennsylvania is the first one there. It's McNeil. So in McNeil, I think the trust was set up in 1958, so it was a long, long time ago. It was a resident of Pennsylvania, set up his trust, put a bunch of assets in the trust, had PA resident beneficiaries. And then in I forget what it was, maybe it was 2000 something, Pennsylvania challenged the fact that they weren't paying income taxes on the money. PA's simple, as we talked about. Resident, set up a resident as a trust, so it's a resident beneficiaries who should be taxed on the income, so you have a resident trust, and it should be taxable. The court basically said that's not enough to create tax. Since we have a trustee that was, in this case, was Delaware, was an out-of-state trustee, the assets are held out-of-state, that we cannot be you cannot tax that in Pennsylvania. You do not have the word a sufficient nexus to create a connection to Pennsylvania and create income taxes. So in this case, this trust was deemed to be non-taxable for PA, and to tax it in PA, it would violate the Commerce Clause of the U.S. Constitution. And then there's been a whole list of other cases that kind of follows this argument, and they're in different states. There's one in Jersey, there's one in Minnesota, North Carolina, and the basics of each of these cases is the same. The trusts are set up by a resident of the state, or in some cases it just has a resident beneficiary, but the assets are listed outside the state. The trustee's outside the state, and the trust is administered totally outside the state. In every case, the court has ruled that cannot be taxed in that state. So, could you imagine, how powerful this could be to shelter income? I got an individual set up his company, put it into a trust, sold it for $20 million just in Pennsylvania. Pennsylvania is a pretty low income tax rate, but now they sold it, they sheltered $600,000 of income taxes. Just by setting this trust up properly, setting it up in the right jurisdiction, having the right trustee. So it's a powerful income tax technique. Pennsylvania itself, if we're in Pennsylvania, it gets a little tough. A lot of these states have obviously challenged it, and they've tried many different ways to tax the income. In Pennsylvania and other states, there's one issue that I've always come up with, and that's source income. So interest and dividend income is not considered source income to a state. Source income is business income. So if I have income that's being generated from a business, just say that's located in Pennsylvania, there's really no way to get around paying income taxes in Pennsylvania on that income. It's source income, it's earned in PA, you have to pay income taxes. Someone has to pay income taxes on that. I've always found when we set up these trusts, we try to keep this source income out of PA. I mean, keep the investments that generate source income out of PA. That has not been actually litigated in PA. It has been litigated in New Jersey on and these things are very similar. So it is not the Kastner case, but it's the Krasner case, I believe, that they say it very similarly, where there was basically a small amount of source income in New Jersey. New Jersey's argument was that actually made it taxable, this trust, because it had everything else. It had its trustee outside. The assets were outside other than this investment. Actually, and the court did not still ruled it was not taxable. But New Jersey has now closed that loophole and basically says if you have source income under this scenario, you're going to be taxed. This trust is not going to be exempt. The Fielding case, which was also up here, is another case that In Minnesota, it was S corporation income, which actually had source income, but the courts in that case determined that was intangibles and didn't actually look at the source income issue and still determined that was not taxable. But I say do not put source income in these cases. Do not put operating businesses that are in Pennsylvania inside one of these trusts. So that can create a problem.
Yeah, if I could just jump in, and Dan and Christina, if you want to sort of comment on that, and also leading us to the Supreme Court case that gives us really tremendous guidance across the board. But how have you wrestled with the non-sourced income issue, and how are you advising clients on that?
Yeah, so the way that we handle that is if we have a trust, and let's say it's Pennsylvania, and there's a Pennsylvania business, and there's other assets, pardon me. We'll typically divide the trusts into two parts, the Pennsylvania assets and everything else. And then if this was an existing trust, let's say, we'll move everything else, that portion of the trust, into another state. There's not really anything we can do about the Pennsylvania trust. Oftentimes you have to switch the trustee to an out-of-state trustee. You got to hire Bridgeford, whatever the case may be. And you have to pay them less if you keep the business part in Pennsylvania. Yep. So it usually makes a lot of sense to do it that way because the benefit isn't the same.
We've had that situation. In one situation, what we ended up doing was forming a C corporation. We actually had two trusts that were owned by a husband and wife located in Delaware, and we had the trust own the C corporation because the C corporation isn't going to throw off source income to the trust. It's not a pass-through entity. It's going to retain its own income. And we had a C corp with an intermediary in the middle, and that's how we avoided that issue. Of course, it's a C corp. This client happened to love C corporations, so it worked really well.
And I think one of the important things there, excuse me, we both have colds. Excuse me. One of the important things there, I think, as to Dan's point about our ability to do that, actually divide the trust so that we could isolate the Pennsylvania source income, really does stress for those of you who are working with lawyers and CPAs and other advisors, really does emphasize the fact that we need to, as draftspersons, we really have to draft as flexibly as possible to include powers to divide and make sure that we're giving the trustees adequate authority within the trust instrument to do all of those things. Now, state law does allow us to divide anyway. It's much easier, however, with respect to the process if the provisions are in those trust instruments and we can just do it by family agreement, and it's a much easier, cleaner process. So that's just a side to how we get to this great result. We have to hopefully have good documents to start with.
Any questions on that? Because really, it sounds like it's nuanced a bit, but the reality is, in the right circumstance, it can be a tremendous tax play, particularly for New Jersey residents being mindful of that case. But any questions, comments? So what I'd like to do is sort of go, if we could, to have the.
I just
Please,
wanted to
please.
mention one thing. So we have a lot of people, and eventually they decide they want to move trust out of state, either because it was a grantor trust that became a non-grantor trust, or we turn off grantor status, or whatever the case may be. I apologize. I'll talk louder into here. And then what we find is, let's say there's a family office, and the family office, I just had a conversation with somebody today. They're thinking about moving things to Florida because there's folks that would be the trustees that live there. The problem is they have this robust family office in Pennsylvania, and even though you'd have the family trustees in Florida, they do all the work in Pennsylvania. So you run into this real problem if there's an audit about where the trust is actually administered, which I think could be insurmountable. There's just not a whole lot you can do about that if the facts are that you haven't really moved the work on the trust out of state.
That's a great point. If I can comment on that, just because, we are, as a trust company, at the end of the day, the great planning that the three of them are doing only works if the trust company is administering trust properly. So in our case, administration has to happen in South Dakota, and if it's not, all of this planning can really be pierced. So that's a really great point. I mean, your documents can be perfect. Your tax analysis could be perfect, but if somehow Bridgeford's caught administering a trust in California, which we never would because we don't, that could destroy all the planning.
Yeah, I mean, it all sounds simple. I get assets, I put them in a trust, my trustee's out of state has no income tax, there's no connection to the state, Sounds really easy, but really it isn't. It's complex. The drafting of these documents, you really need somebody who knows what they're doing. Not everybody does this. And it has to be drafted properly with the flexibility, as Dan mentioned, to change things if necessary, but it is very powerful if done correctly.
And I think finally, just to add a final cap on this, I think this discussion in itself demonstrates just incredible need for everybody to work together. That is the whole team around, the high net worth family client that has built this team to look at the accounting side, the tax side, the trust administration side, who's going to be doing what, how are we all working together. So I think we all agree that that's just a very important piece of this, as you can see it. It requires everybody sort of doing their part and knowing where the assets are administered and everything else. So.
It's like Hillary Clinton said, it takes a village, right? Was that the wrong political figure to bring up? I don't know my audience, I guess.
I will say, because we can't help ourselves, if we're creating a new trust, we create a lot of grantor trusts because that's very helpful in saving estate and gift and GST tax. So you really have to balance
Yeah.
estate tax savings sort of vehicle against an estate and gift tax saving vehicle.
That's a great point, and I got that question today. Well, great, you can save on state taxes, but what if you trigger a higher federal state tax bill? And it's situational, and it's just math, just math. I just wanted you, the three, maybe to comment just very quickly, because for many years when we launched Bridgeford, these cases didn't exist. McNeil was pretty brand new after we launched Bridgeford, but intuitively, we had really smart attorneys like the ones on stage and people in the Northeast and people in Miami that were telling us, look, intuitively it didn't make sense for Pennsylvania to be allowed to tax undistributed, non-sourced income. It just didn't make sense because it was a jurisdiction issue, and how can Pennsylvania and New Jersey tax something that it doesn't have jurisdiction over? So all of this was sort of how many angels could dance on a head of a pin at a conversation at the Union League, and then all of a sudden we have these cases, and then even more compelling is we had a Supreme Court case called Kasner, and we're not going to read through it and go through it in detail, but I mean, that was one of the first tax cases, Dan and Christine, 50 years or something? And it was pretty, a little narrow, but kind of confirmed for us at the Supreme Court level what you all thought, right? So how about you guys comment a little bit on that? Because to us, that was a big deal. That was a big win for the taxpayer, and it confirmed and affirmed what we've been thinking since 2011.
You want to comment? You were doing all the cases. I didn't realize it was going to be like law school tonight.
I said I don't want.
Socratic
I
method.
said I don't want to do anything on cases.
Well, I think the essential takeaway for this group, without really boring everybody to pieces and without us having to get out our textbook and reread the case, because we haven't.
Well, they're all
read
going to
the
get a
case
copy. They're all handing out copies right now. We're going to go through it together.
The takeaway is that the due process clause really is an important clause.
Right.
And essentially, in that case, North Carolina statute, which subjected the trust to state income tax, looking solely at the beneficiary's residence, violated due process. So I think, the takeaway that I think we have for that is that, number one, the due process clause has real merit. Number two, still, notwithstanding these court cases, it is a facts and circumstances case. I think we are not going to escape this analysis of, where is the grantor, where are the beneficiaries, where is the trust being administered, is the income being distributed, is it being accumulated? All of these things I think will continue, notwithstanding all of these court cases and the Supreme Court cases. It still will continue to be very much a fact and circumstance-based case, and the best we all can do is do that planning, I think, in advance of ensuring that we're administering the trust in the right place, that we've considered all of the income tax ramifications vis-a-vis transfer tax ramifications. But I think, in terms of the litany of cases and irrespective of whether it was the one case in Minnesota, this case in North Carolina, we're all kind of ending at a place where ultimately the highest court in the land says, well, we're going to have to look at facts and circumstances.
Yeah, no, that's perfectly said. And for me, it gives us solace because from the beginning I said big ideas. At least we have some guidance now. It doesn't escape us to understand each factual situation. But Dan, what do you, how you and I were pretty excited about when the case came out, but you were quick to caution me, hey, this is a little bit narrow. So I think that's a good point.
Yeah, I think that it really hasn't changed what we're doing. We're still moving trust out of state to save state income tax.
Right.
So I don't think it's changed any planning. We're still doing the same thing. I don't think there's just been more and more focus in estate planning on state income tax planning
Right.
as a major component. It's really not that different than there's been more focus on people moving out of state to Florida and Tennessee and the like.
Right.
But you sort of look at those two things, you just know there's going to be more audits because the states need money
Right.
and there's just a lot of revenue. And for really wealthy people, one day you don't pay any tax anymore on your trust or individually or both. The audit's going to come.
Yep.
Yeah, I think it's just one more piece of the roadmap that we, need to follow when we're drafting, or when you're drafting and we're planning and setting up these types of trusts.
Well, and also underscoring just how important selecting proper jurisdiction is, right? So it's up to the technicians here to do the nuanced planning, and up to a trust company to administer it correctly. But if you take it back up to the idea of perhaps maybe the most important decision when you're doing trust planning is putting it in the right jurisdiction before you even decide what the trust looks like, I think that's the point, right?
Yeah, I guess too. Maybe the most important thing is, are you willing to put these assets in a trust, and what is your purpose for doing it? Yeah. And then you kind of, we ask those questions, and then we figure out, what vehicle works the best.
Absolutely.
Obviously, we kind of guide them a little bit too of what else they can do, but our key question is always, are you willing to put these assets in this trust and lose at least some access to them?
Right. So we're just going to skip around a bit on more advantages of getting trusts perhaps out of South Dakota and Pennsylvania. This is kind of a myopic, and we're not going to spend much time on it. I know our PPI friends in the audience know this very well, in particular, right? That, to be honest, I don't even think I knew what insurance. How many people here know what an insurance premium tax is? Right. I didn't. And, not that I was a tax guru, but I thought starting a trust company, I should know what that was, and I didn't. And it applies to PPLI and some other types of insurance, and it can be an onerous tax. And again, just by selecting the proper tax jurisdiction, you can avoid, I think, Steve, what is it in Delaware? In Pennsylvania, it's 250 basis points, something like that? Yeah. And Delaware, they think they've abolished it, but they didn't. It's nuanced, but it still applies. And so my point is, and maybe one of the three of you can comment on it. That can turn into a pretty significant savings if you just pick the right jurisdiction. So a little myopic, but another reason why we need to pay attention to where these trusts are. And Steve, I know you know this well. But anybody here? How have you seen this conversation? Because I know you've looked at PPLI and worked with lots of different providers.
Well, so I knew it was 8 basis points because we've looked at it with you on some really big.
Well, you could have told me when I first met you.
Because we were going to place some really large portfolios of insurance on folks, and I think the thinking was that the pricing would be better if the insurance premium tax was lower.
Yeah.
And I believe South Dakota is the lowest one in the country.
It is right now. The next lowest is Alaska, but it's colder there than South Dakota, so you should go to South Dakota instead.
But it would seem to me if you're picking one of the favorable jurisdictions, and it's specifically an insurance trust,
Yep. Oh, absolutely.
that's a pretty compelling reason
Absolutely.
to go there.
So really the point is, and I don't want to cut Mike off with that, and I do want to linger briefly on the dynasty trust just because it's important from a jurisdiction selection, and we can comment on it briefly. But, what we're talking about here is really just making real savings, not tax evasion, but tax planning that happens just, again, by following the rules and paying attention. But to go back to kind of where we began, I'd love for you all, and Mike, you can lead it. First of all, dynasty trust. Show of hands. How many people know what that is? Excellent. For those who don't, who those who want to know a little bit more and why jurisdiction matters, because although now Pennsylvania you can do dynasty trusts, it doesn't mean the inquiry ends there, because maybe it's still not the best state to put your dynasty trust in. So, Michael, why don't you kind of go through it? Let's go from here.
Yeah. So basically, trust for umpteenth years, whatever it was, had to end. It was called the law of perpetuities. Against perpetuity. So a trust could not be made that would never end. It couldn't go on forever and ever and ever. And in a lot of states, it's still that way. There has to be an end. And having an end means the assets have to be distributed out. So there's no further protection of the assets, there's no further income tax savings, et cetera. A dynasty trust basically is a multi-generational family wealth vehicle that doesn't have to end. The trust never has to end. It can just continue in perpetuity, which is very powerful from passing on income from generation to generation, skipping the GST tax, presumably, if it's, I guess, structured properly, skipping, generations of estate tax. And I don't know how many states allow dynasty trusts now. I don't know if anybody knows that figure.
Yeah, I'll comment on that, and I really want Christina and Dan to. What's interesting is this concept of how it lives forever, and the rule against perpetuities was this terrible arcane rule that came out of England. And South Dakota was the first to abolish it because it was unworkable, and it's because the largest families in the country didn't want to have their trusts, didn't want the government, rather, to tell them when your trust had to end, because when there was an outright distribution, there was tremendous taxation, especially as these trusts got large. So that's the theoretical framework. Several states have come forward and said, well, we have a dynasty trust, we now have a dynasty trust. But the pure definition of a dynasty trust is that it lives forever. And so be careful in states like Nevada that say, well, we have a dynasty trust, where they really don't, because it ends in 365 years. Sure, it's a lot of years, and we're all not going to be here then, but it ends. And that's not the definition of a dynasty trust, in my opinion. Some states have abolished or changed their rule against perpetuities in violation of their own state constitution. So there's other issues you need to be aware of. But in my opinion, this was sort of the beginning of modern trust law. But Christina and Dan, I think for those of you who know what a dynasty trust is, I do think this is the very foundation, in many cases, for your planning, right?
Yeah, and I think that the most important thing for me, and then I'll let Dan speak from his perspective, is that most people, most ultra high net worth or high net worth family groups will come in and say, I want a dynasty trust, because everybody uses that term with a small letter D, but very few people know what that is. Essentially, it is just that, a trust that will last perpetually, forever, from generation down the generations without an end. The rule against perpetuities that Mike mentioned was the nemesis of all lawyers. Probably many of you in the room remember having to sit through property class and have to learn that arcane rule of 21 years after the death of the last person living at the time. It was just
Wow, you remember the definition.
Well, I've taught trust and estate several
I was
times.
glad it was abolished because I never understood it. So I'm like, well, now I don't have to understand it.
But
So it's perfect.
it was arcane and everybody's eyes glazed over. But the bottom line is that this ability for states to create, for us to create trust that can last perpetually is extraordinarily powerful. And it's powerful for the reasons that we've said, that is that trusts will last forever without having to distribute out at a certain point, which will then force the assets to be taxed. But the more important takeaway here is that dynasty trust, coupled with the generation skipping tax exemption, is what really makes these trusts powerful. And so part of the planning, I know Dan will talk about some very specific cases that we work on in our office. Part of the most important part of the dynasty trust planning is really the combination of that planning with the generation skipping tax exemption. And so essentially, from a very high level, very quickly, it wasn't until the 1980s where Congress said United States social policy should be that at every generation there should be a tax. So either, assets go from one generation down to the next, it's either subject to a state tax or another tax, but it has to be taxed. The other tax was called the generation skipping transfer tax. So now the ability for us to use our current exemption, which is changing, we'll talk more about that later, the ability for us to allocate this exemption to dynasty trusts that are designed to last forever is, as the economics would suggest, extraordinarily powerful to pass assets down generation after generation after generation. And the comment that you made that we all chuckled about, 365 years or 1,000 years or forever, actually means something, because we have trusts, in our office from, 1923, and there's 1948, and much of the planning we've been doing of late really is families looking at G4, G5, G6, and saying, okay, we're projecting out, And the assets from this trust, which have lasted a really long time, and we thought were going to last, into, we've now have all these generations, and there's a lot of money. Now we know that in generation 5, for example, the trust is going to end, because this was before we could let trust, last forever. So now the planning really is around, okay, what are we going to do about that? We know that in 30 years from now, and whatever, generation 5 or something, all of these hundreds of millions of dollars are going to come out to these people. What are some of the things that we can do to solve that problem? And those are the kinds of things that we're thinking about now. Now, in the future, hopefully, with all of our South Dakota trusts and our Delaware trusts and wherever else, we're not going to have to be facing those same kinds of planning problems as much, because more and more states have done away with the rule against perpetuities. So it's a luxury. But I think that the important takeaway for us, and really one of the most powerful things, is making sure that generation skipping tax exemption, which everybody has, because it was only designed to sort of, affect the very wealthy in our society. What is the best use of that exemption? And of course, coupling that exemption with a dynasty trust usually is the most powerful and effective way to pass the assets.
Absolutely. I mean, this isn't theoretical. Again, how many angels get dance on the head of a pin? There's some real practical results here. And I say again, just by choosing the right jurisdiction. So I'm going to ask Dan and Christina to talk and sort of build on this and get, I think, it gets a little bit more exciting, because then there's some particularly interesting strategies, some of which are controversial in some states, but still certainly viable for Pennsylvania and New Jersey residents, leading right into the incomplete non-grantor trust. So, Christina and Dan, why don't you walk us through some of your favorite specific strategies using a top-tier trust jurisdiction?
Absolutely. I'll just say one thing on the dynasty trust first. There are certain states where there's not a rule against perpetuities, and I know you said earlier you have a strong conviction that if you can do state income tax planning, you should. I think if you have a state with a wealthy person where you're creating a revocable trust, let's say New York, for instance, you absolutely should be thinking about creating that trust outside of New York. Yep. I have a case in the office now where there's several $1 billion of trusts that were created, all in New York, wow, which just doesn't make any sense whatsoever.
Well, we're going to play around as to whether or not there's even a fiduciary duty to get get that trust out of New York. But please, take us through some of your favorite real-world strategies that really are practical, not theoretical. These work in the right circumstance.
Okay, so a sort of standard trust would be that you create a trust and you make a gift to it. So let's say a parent creates a trust for a child. They put $1 million gift in it. That's what's called a completed gift. That's just sort of a normal trust. And a lot of those trusts, the way that they work is they're the type where the settlor, the dad in that example, is the taxpayer. And that's a pretty traditional sort of estate planning vehicle. In that case, there's not really a state income tax planning component because all of the income would roll up to the father. There's another sort of vehicle where, and a lot of times this would be because you can't really do a completed gift trust. And there's some states where you sort of have to do a completed gift trust for this to work. But if for whatever reason, let's say you've already done a lot of estate planning and you're out of exemption to do it, you can do what's called an incomplete non-grantor trust, or in South Dakota, an SDING.
Something
or
clever.
In Nevada, it's a NING. Or
Acronyms. Estate planners love acronyms.
There's many, but they're all called INGs. So essentially what you're doing there is the trust is set up in a very specific way so that you make a gift to the trust, but it's what's called an incomplete gift. And what that means is you're not using gift tax exemption to make the gift because the ING trust is not a estate planning vehicle. It's still in your estate. But it's also a non-grantor trust, which means that the trust is its own taxpayer. And then what that essentially lets you do is do the state income tax planning we were talking about before. So those are often used in anticipation of a business sale. We used to see them most often, I would say, in California. Bunch of years ago, New York outlawed them, and California caught up. I think that was 2 years ago. So in California, you can't do that. So a lot of what's been going on is where there's completed gift trusts, they'll turn off grantor status and move them out of state. So more traditional planning, turning off grantor status and moving out of state. They wrote a very good law, making it essentially impossible. And you sort of have to assume that others will follow. I think people were getting a little worried about New Jersey, but nothing's happened.
Right.
So,
Well, talk about the practical impact, though. So somebody with a low cost basis company that they started from scratch and put a $20 million value on it. What kind of savings are we talking about? Let's use New Jersey as an example. I mean, we're talking about some real potentially huge savings.
yeah. So essentially what would be is if you sell your company, very basic example, and it's a New Jersey company, you're not paying New Jersey tax when you sell it. Don't make me do the math. But
See if we did the math here.
All
Oh,
right.
there we good. I think we
You
did
did
the
the math on
math.
page
It
two.
was a leading question. Sorry.
I
I knew what the next slide was, Dan. You didn't.
all right.
Right. So I'll just jump in. I mean, when you distill the words down to like one sentence, it's a real savings. And until New Jersey attempts to outlaw it, or even Pennsylvania, I mean, 6% sounds like a lot. Even if it's just 3%, you're still looking at $600,000 tax savings. That's a lot of money to me. And your clients and the people you work with will be pretty happy when you come up with a solution like that, right, Dan?
Yeah.
And then, I was going to say, if I just could, and then if you have that money, the cash that's generated, and you've saved all that money, and it sits in a trust that's properly cited in a jurisdiction like Delaware and South Dakota, what other tax do you avoid? A little quiz. State income tax on undistributed income, because that is considered non-source income, right?
Yep.
So you have a double tax play.
So they're still used a lot. And I'd say we weigh, can you do a completed gift trust, a regular sort of estate planning vehicle? Because again, you have to weigh the estate tax savings versus the state savings. But there's a lot of people that say, I don't really care about the estate tax savings. I don't want to pay tax now.
Yeah.
So there's a lot to consider there.
So even people with exemptions remaining, you would potentially do this?
Well, we would talk about both, I think. It's you're probably giving up. So if you have a company and you can discount it and do some traditional estate planning, you probably can really advance some significant future death tax savings, but you have to die to realize the savings.
Right.
And they may say, well, I don't want to pay that $1.2 million, and I can invest that $1.2 million. So it sort of depends on the person. We'll see these a lot with younger people. They may not have any kids. They can't see that they're ever going to die. So it doesn't make sense. We just did a great project with Bridgeford where we had some people in their 40s, and they happened to have some existing trusts. And it was sort of interesting because there was 4 partners. 2 of them were really long-time clients. Everything was estate plan. They don't actually own anything. Everything was in GST exempt trusts. And there's 2 younger partners. We just did their estate planning and we sold their interest to trusts. So the 2 younger ones, they have a Pennsylvania, New Jersey trust, but they're grantor trusts. The other 2 where we did all the estate planning, we decanted those trusts into South Dakota to be non-grantor trusts because they foresee a big sale of that business, and also they're seeing their income tax start to grow. So it's an interesting sort of comparison with 4 partners in one business.
No, it's great planning. We're happy to be part of that. So I want to transition over to slats. There's a lot of conversation about slats. They've been around a long time. How many people have worked with them, seen them, maybe even recommend them? And it's interesting. I'm anxious to get the opinion of everybody on the panel because not everybody thinks they're a safe move. Bridgeford is agnostic. We will administer to them, but some attorneys around the country do not like them because they're tricky. And if you don't do them correctly, you could get in some trouble from a tax perspective. I would love your thought. I mean, first of all, let's define it. Please define it for those who don't know what it is, because it's not really that complicated. Then talk about why is there controversy around these?
Well, the SLAT, again, the acronym, Spousal Lifetime Access Trust, is essentially a trust. One spouse creates a trust for the benefit of the family, but the other spouse is a beneficiary. So it's simply that. You know, one spouse can create a trust. If the other spouse is a beneficiary, technically that is a SLAT. We've been doing those for my whole time, you know, years and years and years. Leading up to the last administration, when Biden came into, leading up to what became the Biden administration, part of the platform was a reduction in the exemption amount, down to $3.5 million. That did not materialize, but what we were seeing in our office was all of a sudden everybody, literally, and referrals and clients and everybody saying, hey, I was at a party and I heard about a SLAT. I want a SLAT. It was just,
I don't want to be at that kind of party. They're talking about slats or incomplete non-grantor trusts. If that's okay.
Agreed. So, you know, once we cut to the chase, really what had been, it became a big marketing tool is what I'm trying to say in a polite way. Everybody was marketing these slats. Typically what was being sold is, okay, spouse one can create a trust in which the other spouse will have an interest. Spouse two creates a trust, and spouse one will have an interest. So I'll create a trust for you, you create a trust for me. Isn't this great? We're going to have our cake and eat it too. We're both going to part with assets, but I'm going to be able to share in what you gave away, and you're going to be able to share in what I gave away, and it's a miracle. Well, that's the problem. It is not a miracle. You cannot have your cake and eat it too. And the difficulty there is that, number one, there is something called a reciprocal trust doctrine in the law. The IRS says you can't do that. You can't, you know, I'll do this for you, you do this for me. If you unwind it, you've not changed anything, you've not parted with anything. So that's sort of logical, right, that wouldn't work. So the tricky part, at least from the drafting standpoint, is how do you make those two trusts somewhat different? Typically for one trust, you know, for one trust, the other spouse could be a trustee. For the other trust, commonly we'll have an independent trustee, whether it's a corporate trustee, you know, like Bridgeford, or another individual independent trustee, along with some other differences in the two trusts to make them non-reciprocal. So that's a very important piece of that. The other danger, I think, that I see and I've seen is that because they were so popular and because so many people were marketing this technique, it wasn't all the time fully explained. And by that I mean, remember I said earlier about the benefit of the generation skipping tax exemption as to trusts that are designed to be dynasty trusts. Well, all the slats that we're doing are designed to be dynasty trusts. They're all designed to last for generation after generation. And ideally, for people who have exemption remaining, and if we have the right assets, we'd like to allocate that generation skipping tax exemption to really to make the dynasty trust a real home run. Now, that means that it's really not intended for either spouse to use those slats as a family bank or as a source really of funding generally anyway. We'd love for the assets to just part with the assets, use it for assets that you're comfortable that you're not going to need, and forget about it. But what I think we were seeing a lot of was people being told, no, you're going to be able to just use it. You know, the spouse will be able to have access to it. It's great. It can be like a family bank. Now you can do that, but it minimizes the tax effectiveness of it. So that's also just a warning sign that I've seen. And I think people were trying to use this big exemption when we realized we were going to have a larger exemption. They wanted to hurry up and take advantage of it before it went away. That's part of something we'll talk about in a little bit with respect to whether it is going to go away. But people sort of in a, not the truly high net worth, but maybe, people who were hovering at where it was meaningful to give away a significant amount of money, this technique became very popular. But there are those tricks that I think people just have to be very careful, and pitfalls that you don't fall into.
I think with that family bank concept, one of the things they don't realize, if it's your own money, you can spend it however you want. But once you put it in a trust, then you're a fiduciary, and the remainder men are often your children. And while it doesn't happen often, your children can sue you. That's Jen's specialty. So, there is...
If you want to sue Bridgeford, call Jen,
Yeah,
please.
yeah.
That'd be great.
There's a certain risk to that, because if you start to take out all of the money, it's really no longer your money. You have a beneficial interest in the trust.
So there's two problems I'm hearing, right? So conceptually, it sounds like a miracle. If the trusts aren't drafted perfectly, it doesn't accomplish what it's supposed to. And the other problem is, what if the trust company's not paying attention, right? And so and we're going to get to a minute distinction between a directed and discretionary trust. But I mean, the devil's in the details of how these things are administered. And so we've seen some really poorly drafted slides where we're saying, look, we're not doing it because we know if it's audited or taxed, it's not going to work. And so it becomes a challenge where we get excited and everybody sells the big idea. Well, while we all love big ideas, again, they only work as well as they're drafted and administered. And these have a lot of pitfalls. I'm not discouraging them. I'm just saying let's just do them correctly so we don't get our clients in trouble.
The other pitfall that is rarely discussed is that on a divorce, the settlor of the trust remains the taxpayer unless you do some trust restructuring. So now your ex-spouse has to pay the income tax on that trust forever. The only way
if my ex-spouse has to do that.
The only way to get out of that is that you have to have an adverse party decide to make the distributions, which is basically other beneficiaries, which is typically your children.
Yep.
And if they're minors, that's not going to work. And even if they're not, who wants to have their kids decide if their parent's going to get money? So it can be really problematic.
I see the issue when you have, I'll call it marginal, a guy's got 26 million and they took advantage and this technique, and they didn't, the non-grantor spouse, they don't have life insurance on them, so and that spouse dies, and now the spouse who remains has no longer access to these assets, even if it was just the income. I don't think that obviously has not been baked out yet because most of these have been done in the last 2-3 years. I see that when that starts happening, that could present problems. Just like any, almost like any trust. when the husband leaves money for the spouse and she finds out later and is like, well, what? I don't have all my money?
Yeah.
But yeah, I see that could potentially being an issue down the road on these things.
Yeah. So before we transition, we kind of want to end with some discussion on modern trust law, and I realize we started later, so we want to kind of get you guys back to your food and drink. But, Christina, you had mentioned, the conjecture of what may happen. I know none of us could really tell the future, and I'd love for people, too, here that's listening, if you have an opinion. But when we talk about that, I mean, we've talked about a lot of advantages, some strategies, but, are we facing calamity here with changes? What's your crystal ball say?
We're not going to talk politics.
Oh.
But,
Okay.
but irrespective of one's partisan views, political views, there is a lot of change, clearly, with the next administration in every aspect of our country, which undoubtedly will affect tax planning. From the pure transfer tax side, that is the estate and gifts tax side of things, a top priority probably will be extending the tax cuts. So the Trump tax plan is set to sunset January 1, 2026, so just a year from now. And so much of our planning really has been using the exemptions and all of the techniques that we've been doing to hurry up and maximize that before everybody's exemption effectively gets cut in half in 2026. Now it's looking possibly, maybe more likely than not, I think, that we won't get to that reduction in 2026, I think, unless, all of the other things that are being done in terms of the inflation, all of the other things that we're doing in terms of cost cutting in the budgets and overhauling many of the departments in Washington and the government bureaucracy and everything, that may push the tax planning farther down. I don't know. But I think the important thing, and I'll let Dan certainly comment on his point of view and any of you, from our standpoint, it doesn't really change what we do, because we're ultimately, whether it's a 4-year situation that we're looking at, whether it's a 2026 situation, Republicans may only be in control, for the next 2 years, in which case we might only have a 2-year window, and there might be another attempt at legislation. So we're still going to keep doing what we're doing, and I really caution. We have lots of clients, some clients calling and saying, should we halt? We've spent all this money on our appraisals. We've got these strategies in place. Should we stop? We were going to use the next generation's exemptions. They're only 21. Can we do this? And I think, my personal opinion is that we should not stop with the planning, because particularly for business owners and people who have significant wealth, over time, they're just going to get richer. They're going to get wealthier. And the longer one delays on the planning, the aggressive planning, to begin to continue to chop away at that tax bill, it just becomes extremely difficult. I mean, we're good, but there's only so many things that you can do, without really taking an aggressive, proactive approach every year, year over year, and just continuing to look at that tax bill. So we're going to see a lot of change. The question really is, what does it really mean from our standpoint? And I don't think it's going to change what we're doing.
Well, there's still uncertainty, like we started. There's still uncertainty. So go ahead, Dan.
And I think if something happens, we don't know when it would happen. I just saw an article that they're guessing maybe it's in December, which is where we've been before. So if that's the case, we still have to keep going like it's going to sunset. Maybe it will, maybe it won't. And there's so many components to those tax cuts and so many campaign promises that are tax related. There's just no reason to not go forward. And we've been here before. We had some clients where we made gifts at the end of a year where we thought things were going to change, and they didn't. Yep. They grumbled a little bit, and then you look a few years later, we moved a fortune out of those people's estates. Yep. So I don't see how we would change.
I agree. Mike?
Yeah, I mean, you just don't know what's going to happen if you just take one small piece of the conversation of immigration. If there's any real push to, deport immigrants who are here illegally, how do you pay for that? So we have programs that the government wants to pay for. Does that, can they do that? Can they do that while reducing, keeping the income tax lower, the estate tax lower? And that's the other thing to think about. We all you ever hear about is the estate tax exemption was going to go down, but there's a lot more things affected than that. Income tax rates were going to be much higher once they sunsetted, and qualified business deductions were going to change, and Section 1. I mean, there's a multitude of income tax items that would be affected, and I cannot imagine all of them are going to just roll forward as they were. So there is a lot to think about and a lot of planning, and to Dan's point, I don't know when that will happen. Who knows when it will happen? It's not something where we can sign an executive order and it all goes away. Right. That appears to be the way of governing these days. We sign an executive order because it's easy, but this isn't one of those. So
that's a great point. Any comments on that? Because I would like to transition quickly to a couple other topics and get you guys back to drinking and eating. But anybody else have any thoughts on that? I mean, I think it was very well said so far, but we can agree there's still uncertainty. Anybody have any thoughts? So I'm going to dance through very quickly some concepts, just because what we've been talking about are some really, you've all been using the word compelling ways to have effective tax planning and privacy and all of the things that our clients want and our families want. But I say we're in an environment where families get all these advantages without having to give up control. And I talk about modern trust law in the context of now you can almost have your cake and eat it too. Families don't give up control. And a lot of these conversations turn on asset protection, and we're not going to get into the nuances and the details of a domestic asset protection trust, but every one of the concepts that Dan talked about, including and Michael, have an asset protection component to it. We just haven't talked about it. They're all irrevocable trusts, and most of them, if not all of them, have spendthrift provisions, so by definition, they're asset protection trusts. And in the United States, there's something called a self-settled asset protection trust, which is a whole other conversation around how you avail yourself of asset protection and still be able to benefit from the income of the trust and still be able to get distributions. So in other words, you don't have to give away all your assets and never touch them again in order to get asset protection. You don't have to go to Cook's Island. You don't have to go to Nevis, and there's a mechanism to do that. And I wanted to mention that every single one of the strategies has an asset protection component, and I can say a big part of the conversation and questions that we get at Bridgeford is, I'm looking for asset protection. I'm worried about what's happening in this country. I'm worried about what's happening around the world. Give me asset protection, and I think everything we've talked about touches on asset protection. But what I really wanted to focus on, and then we'll kind of get you guys back to having fun, although I'm sure you think this is a lot of fun. I think it's amazing. But no, all joking aside, I mean, there's so many changes in the last 20 years, and this quote really resonates with us at Bridgeford, that trust and trust administration and trust planning has been so dramatically impacted that there are aspects of planning that we can do that didn't exist, as I've said now a couple times when I was in law school. And this one I want to linger on for just a minute. How many people are familiar with a directed trust? Right. It has revolutionized the industry, and it has taken what was once a very rigid, unchangeable, expensive approach to trust administration and making it, and made the whole process easy to work with. More importantly, giving control back to advisors, settlers of trust, and beneficiaries. And it's a very simple concept, and sometimes we end up taking too many words to describe it. And so for those of you who aren't familiar with it, a couple of things you need to know. There is no directed trust statute in Pennsylvania. Lawyers in Pennsylvania can say they can draft you a directed trust, but they could also tell you the sky is blue in the trust. If there's no statute there, you have to be very careful. And I'm going to have Dan and Christina talk to you about that. States like South Dakota, Delaware, Nevada, they have a statute. That's where you want to focus. If your client wants a directed trust, I think you should go to the right jurisdiction that has it actually defined. South Dakota defines it very well. In fact, so well, other states have stolen the statute. And basically, it just bifurcates liability, and it gives people in your control or your family's control universe the ability to make important decisions like who's going to manage the money. Look, how many clients have been not happy that their trustees, Bank of New York Mellon, and Bank of New York Mellon has to manage the money? How many times have you heard that complaint? The only one? A lot of people have heard that complaint, right? They want to work with their independent investment advisor in the context of asset management. They want to work with an independent trust company. They don't necessarily want to blur the two. And that's the answer the answer to that conundrum has been the directed trust. And I'd love for you to comment on that a bit, because it's so important of a change, and I think it's revolutionized the industry in such a way that it doesn't make the planning that we've been talking about scary anymore, because you're not giving up control to a big conglomerate internet institutionalized trust company anymore. It's going into the hands of boutique organizations, or it should, where you have a lot of control over. Anybody want to comment on that?
Sure, I'd say we take advantage of that in South Dakota and other states, more so than using those states as the full trustee, because many people want the situs, but they want others to be the trustee or other roles in the trust.
Right.
And it sort of makes them more comfortable, and it reduces the liability of the corporate trust company.
Absolutely.
And it reduces the fees usually. So it's a great model.
It's a great model, and again, we're getting a little later in the evening. I mean, we've written a lot about this on Bridgeford. There's some videos on it on our YouTube channel, and it's not as complicated as it may sound. And I can tell you, your families, particularly larger families, love the solution, because again, it gives control right back where it belongs. So let's be frank about that. Shouldn't families still be able to have control over important decision makings, like who's going to manage the money? Absolutely. Absolutely. Have some input and ability to direct distributions? Of course they should, while still availing themselves of some really powerful planning techniques. And this is another quote I love, and we have these quotes that we found when we were launching Bridgeford that really in some ways became our guiding light, and this is another one. There really is a quiet revolution happening, and that was written in 2012 or 11, as I recall, and it couldn't be any more true now. And it's interesting because that word independent trust company and advisors I mentioned earlier is kind of now under attack, because companies that were once independent and privately held now are sort of selling themselves back into the multinational conglomerate. And I don't need to tell you, I think the dangers that our industry faces when all of a sudden your trust company becomes part of a multinational trust company with 6 charters around the world based in the Isle of Man. Is that really good for the end user client that signed up for a boutique trust company where they knew the name of their trust company, where they wanted to develop a relationship, a personal relationship? No, it's not good for the industry. And I don't say that in a self-serving way. I say that as a human. I mean, I think that in our industry, it's still a relationship business. You want to develop a relationship with your insurance person, with your lawyer, with your trustee. And these large conglomerates, it erases all of that. And I think we have to be careful about that and guard against it. Trust protector is just another mechanism. Pennsylvania has a trust protector. I'm not even sure, it's not a statute, and it's really myopic, or not myopic, it's very opaque. It's hard to even define it in Pennsylvania, which is why people like to appoint trust protectors in jurisdictions like South Dakota, Nevada, and Delaware, because a trust protector, as we say, is a super trustee. Has more power than the trust company, is really a checks and balances over the trust company, can replace the trust company, can replace the asset manager, can reduce beneficial interest, has enormous amounts of power. Why do families like this? Because they can appoint their brother or they can appoint their CPA, and presumably they're going to do what they're told by the settler, because that's sort of the mandate, as long as it's illegal, right, Dan? I love the concept. It's a European concept initially, right? You want to comment on that?
Yeah, I think that's exactly it. We do have people, though, that worry if there's a trust protector when they're not alive, that they can change beneficiaries or divert money to charity.
Yeah.
That becomes a little scary then. So we sometimes will use them to carve out specific roles or to change certain numbers. There's lots of ways that you can do it.
Absolutely.
So sometimes they're broad, they can amend the whole trust, and sometimes very specific.
Right. And it's situational. So everything we've talked about is situational, but the reality is when you look at the trust protector in conjunction with the directed trust, I'm here to tell you it has changed the trust industry and has made trust not scary, not as expensive as they used to be, and has been really the reason why Bridgeford exists, because we fell in love with this concept of delivering control back to families and their advisors.
I'll say, though, that most trusts are drafted where the trust protector is not a fiduciary, so it reduces liability. But then we also find most are drafted where they're not paid,
Right.
which creates a real problem in getting somebody to do the job if you're going to remove a beneficiary or something like
Absolutely. Too much liability.
that. It becomes a very hard job to fill.
Absolutely. Another quick concept, I'll touch on it for 10 seconds, called Family Advisor. That's kind of a trust protector light. A lot of families like this, only exists in South Dakota. It's a non-fiduciary position, but very similar, where you can appoint somebody that you trust to be in a role to do what you ask them to do relative to the trust. Again, a lot of that information on our website. Decanting, we mentioned that a few times. That is, to me, the final, sort of, if you call it penumbra, the lawyers call it penumbra of concepts that deliver direction and control to clients. The decant is simple. It's just like it sounds. You get a bottle of wine and you pour it into a decanter. Decanting is the ability to take an old, tired trust that may not function properly, or more importantly, may be in the wrong jurisdiction, or may not have asset protection capabilities, or may not be a directed trust, all things I think we all agree that we want. Through decanting, you can do this pretty efficiently, and in each state, not all states have a decanting statute, so they're not created equally, and I will say South Dakota has been considered to have the most flexible decanting statute. Dan and Christina, please talk a little bit about this, because this gets to my point where irrevocable trusts are not scary. One of the data points that scared people was, well, they can't be changed, and they're rigid, and they exist forever, and there's nothing I could do about it. It is what it is, and it has to stay at Bank of New York Mellon forever because, well, that's just the way it is. And decanting really has changed and turned the industry upside down.
Do you want me to address that?
Yep, either one. I mean, we've used it in a number of instances, but generally, I think, there are ways that there are creative ways to decant a trust, and it can be for a variety of reasons. If there are undesirable provisions in the trust instrument, and you want to get it into a new trust with better provisions, that's the one main reason why we do them, when we do them. Why don't you give some specific examples
Sure. Yeah,
that we've had?
One example was the one I mentioned. We simply did it to turn off grantor trust status. In that case, those trusts were what are called 678 trusts, where you can't turn off the grantor status in the normal way. The only way to turn it off is to decant it. And the trust terms were really the same afterward, just without the same income tax provisions. Sometimes we'll do that if we just don't like the way that the trust provisions are written. Sometimes the issue, though, is that you have to notice the beneficiaries, and you really have to think through if that's going to be problematic.
Do both states need to have the decanting provision, or only the state the trust is?
The state the trust is governed in.
That's a great question. Michael asked the question, do all states have to have the decanting statute? And Dan answered the answer, no, the trust has to be in a state that has a decanting statute, which is where Bridgeford's called in all the time. We're appointed often just because they want to avail themselves of the decanting statute.
Yeah, so we'll move a trust to South Dakota. Sometimes we'll then modify to add a trust protector. Sometimes it's not technically a decanting, but they'll modify the trust.
Right.
It gets you to the same place. And sometimes that's just a way of not having to actually move the assets.
Right.
Or sometimes we'll move there, and then you can get the decanting law to apply, and then we'll decant it. But it all gets you to a place where you can rewrite all or portions of the trust.
And the only caution there, again, is the generation skipping tax exemption, because you have to be very careful that you don't affect that. If you've got a generation skipping tax exempt trust, you have to be very careful that you haven't somehow tainted the trust by the decanting process. So decanting is somewhat of a basic concept when you think of a bottle of wine
Right.
into a decanter. But there are some pitfalls there that just words of caution, if any of you are dealing with it, you want to be careful of that. And sometimes you do want to, you don't want to go to court, but sometimes we've had clients say, we're going to just get this blessed because it's just too expensive if there is an adverse result.
Right.
It's also on a decanting itself. I don't think you can get a private letter ruling, but on a modification you can. So it's sort of 6 of one, 1/2 dozen of the other, but those differences can matter depending on what it is you're doing. But it's sort of all the same thing, practically.
But what it does, although there's situational nuances, is deliver direction and control back to clients and their families. So we're sort of quickly start at the top and then end with the proverbial bang, because I want to do, this is sort of the audience participation, so I'll give you a second to get ready. We started talking about taxation and talking about how there's legitimate ways to save on state tax. We talked about dynasty trusts and how they work, and they have worked many instances for many years, starting in South Dakota. We talked about specific planning tools that actually can save money, utilizing all of these concepts and leveraging the case law that we saw at the Supreme Court level. And we talked about how all of this hinges on what? One thing. I've said it like 30 times, choosing the correct trust jurisdiction, right? Now we ended, or we're coming to the end, by saying you get all of these benefits and also control too. Directed trust, trust protectors, decanting, all these mechanisms that have changed the trust industry in such a dramatic way, and why we get so excited about it. I mean, I always laugh when I was in law school, the last thing, I hated trust in estates. And then I grew up and I own a trust company, I mean, it's kind of comical, but this stuff is dynamic and interesting and changing, and we're changing people's lives, and that sounds a little dramatic, but it's true. I mean, when somebody comes to us with a complicated issue, we have tools in conjunction with your discipline and the fact that Bridgeford will administer it correctly, and that's compelling, which leads to really the way that I want to end this. Is there a duty to decant? And let's make it more broad. Is there a fiduciary duty to move a trust into a more favorable trust jurisdiction? Let's think about this. I was cautioned not to say the M word. What is the M word? Have somebody else say it so I don't get in trouble. Okay, we'll talk about that over drinks. But the question, though, that has become very important, specifically in light of a Massachusetts case where Supreme Court questioned, this is interesting, listen to this question, whether a trustee has a fiduciary duty to move assets out of an unfavorable trust jurisdiction like Massachusetts into a more favorable trust jurisdiction like Delaware, South Dakota, and Nevada to protect assets. Well, let's define protect assets. Isn't tax mitigation a form of protecting assets? Asset protection is for sure. Privacy is another component of it. Tax, all the things we've been talking about. So if a trustee like Bridgeford has a duty to potentially, fiduciary duty, which is a big word, that's the F word, the other important F word that we use a lot around Bridgeford, is this idea that, well, if a trustee has a duty to move it out of Massachusetts or New Jersey to best protect the assets, will they? Will a New Jersey trust company willingly give up revenue and move it to Delaware if it's in the best interest of the trust? Of course it's not going to. Bad business decision. But if it's a violation of their fiduciary duty, what are we talking about? Right? We have these conflicting issues, business versus a potential fiduciary duty. And I'm not making this up. I get accused of that sometimes, and some of this presentation has been made up, but this is actually true. There are actual aspects of treatises, we call them in law school, that guide us on how to analyze trusts. And there's Scott's on trusts and Restatement of Thirds on trusts. And I'm not going to read them all to you, but each of these major treatises, they call them, has a component in there that specifically says, it's not even conjecture. They say there is a fiduciary duty to put trust assets in the most favorable trust jurisdiction. In some cases, they don't say trust jurisdiction, but they say to situate the assets in the most protected way, which I would argue we've been talking about for the last hour and 10 minutes. So I put this question out, and I'll take a position, and then you can tell me that I'm wrong, and I want everybody on this panel. But I am not afraid to say pretty aggressively, I absolutely believe that not only is it a theoretical discussion in treatises that aren't really binding, but I will argue that there will soon be a case where a trust company, or more importantly, potentially a lawyer, an accountant, maybe even a financial planner, may be sued, and for breach of fiduciary duty, for simply not saying, hey, if you cross the line from Pennsylvania to Delaware, or get on a plane and go to South Dakota or Nevada, you could save $2 million on your transaction. Because that's measurable damages, right? We can all agree you can measure damages there. This isn't theoretical anymore. And so this conversation just is, as I keep saying, how many angels can dance on the head of a pin, standing around to Union League, being theoretical and pedantic. No. This is a real question. So I would like you to comment on it, because I'm on the extreme saying I think this industry is on the threshold of a major lawsuit because we're not properly advising on jurisdiction selection, because we've been talking about how important it is. So if it's that important, then how can it not be a potential situation that creates liability? I'd love to comment.
Personally, I'm sure there will be a case, because there's cases against, for example, accounting firms, because you didn't give them the proper tax planning, and it's potentially not improper tax planning, which would affect, obviously, the less, not the corporate fiduciaries, but what about the individual fiduciaries who have no clue whatsoever? So how do you, apply that across all trustees? And I know Dave's our host today, but I do pose a question to you. So you have a South Dakota trust, you're the trustee. Now Alaska has a better provision. Are you moving the trust to Alaska?
We'll go get an Alaska trust charter. That's what trust companies, that would be our solution. If it's about being intellectually honest, right? And I think we transcend being salespeople. And I believe at Bridgeford we're not salespeople. I believe we're thought leaders. And if legitimately South Dakota becomes no longer the best trust jurisdiction, then we'll adjust and make sure our clients avail themselves of the best trust jurisdiction. So I appreciate the question, absolutely. And I will tell you that is another issue that I've seen. A certain trust company will say, yeah, we think South Dakota is great, but we're also going to have Nevada too, so you can choose. I understand the business model, but how about being intellectually consistent with what you've been telling the marketplace for the last 20 years? And that's an issue that I have. Great question, thanks.
Yeah, fiduciary, I'm not positive, but I would say our clients would expect us to tell them about that. And you sort of say, well, where does that expectation end in terms of what it is we should be telling them about, because you can't think of everything. But it's very popular at this point to be thinking about state income tax planning. So I think because of that expectation, you could see that lawsuit coming.
Yeah.
Well, and I think trust laws evolve at a fairly slow pace generally from state to state. So I do think that as the laws become more developed, we will see, I do think eventually we will get to your scenario, because I think that the laws are evolving and becoming more sophisticated, and I think it's a matter of time where we try to provide that kind of proactive advice, and we try to think of all of these things and do that income tax planning. as we evolve and as expectations change, that'll be part of the expected, and that'll be the basic. And I think, again, we'll get to the point where we will see that it'll be much more common. So and that's why you continue to see, companies going out and continuing to form
Right.
trust companies. So that's why your competition is growing, right? And from, other states as well. So I definitely think we'll see it. I don't know when.
Yep.
Yeah. And as advisors, that's why we have E&O insurance.
Any other comments? I mean, I may have taken a hard position. Please, I'd love to hear from you.
Sorry, I don't mean to go back to some of these power holders, but the knee-jerk reaction I think sometimes in the industry is to name an individual as these various power holders. But can you give us maybe some instances where you've started to see maybe like a special purpose entity be named as the power holder, either maybe to cut jurisdiction back to a high-income state, maybe that person as a fiduciary, or are there instances within these family offices where you've seen it shift?
That's a great question. I don't mean to. I want to define what you mean first, because I know where you're going with this idea of a special purpose entity, and then I'd like you guys to talk about how you use it. So, in the context of the question, rather than appoint an individual person to be a trust protector or an investment advisor or distribution advisor in a directed trust structure, many individuals don't want that kind of liability, and they don't like to be named. So South Dakota in particular, and I think other jurisdictions now have caught up, they've codified something called a special purpose entity. So essentially, it's nothing more sexy than just a South Dakota LLC that is named in the position of a trust protector in the other two fiduciary roles I talked about, and it provides a modicum level of liability protection for the individual, and that individual is never named actually in the document. And so that's a great question, and I was going to mention it, but we're running out of time. I'm glad you brought it up. So, and I'll let you comment on it. It does create another touch point for the example. So I'll use the quick example, then I will take it to the real experts. But you have a South Dakota trust, right? And you're doing all the right things in South Dakota trust, but you inadvertently appoint a California resident to be a trust protector, and the settler's a California resident. Well, what do you think the California board's going to do? They're going to claim what? It's a California trust, and they're going to try to tax it. And all the nice planning that you did goes out the window. I'm not making a legal opinion because I don't have malpractice insurance anymore, but there's an argument, a strong argument, that if you create a special purpose entity in South Dakota and drop that into the trust instead of California resident, but California resident is the manager, that avoids that problem. I'll let you take it from there.
Yeah, I think the comment we talked about earlier, getting somebody to fill the trust protector job, it goes a long way. I don't think we've actually had anybody that's wanted to do that yet. It's mostly been individuals. In any new trusts, if we're going to have a corporate trustee, we like to have somebody that can fire the corporate trustee, even if it's Bridgeford. So
I don't like that part.
I know. So I do think, though, because you want to be really cautious if it's a state income tax related trust, obviously that's really helpful where you have a South Dakota entity, and
Yep.
it's less clear who's running that entity.
Yep, another touch point. Great question. Thanks. Hopefully we're somewhat responsive to where you were going with that. Any other comments, questions? You disagree with anything we've said?
Or everything we
Yes,
said.
please.
So we're talking about trustees and survivorship and long-term investment planning. David Warren keels over tomorrow. What's Bridgeford?
Well, Bridgeford's so much bigger than David Warren. I appreciate the question, and as narcissistic as I am, I can tell you I am just one of an amazing team of people. We have a succession plan in place mandated by our division of banking. All trust companies do. So any founder that may appear to be the driver is to be easily replaced by other very talented people that we are tasked with training. And we have so many people on our team that would ensure the seamless operation of Bridgeford. And as much as I'd like to believe Bridgeford can't exist without me, the reality is we've become so big and sophisticated and nuanced that if the worst happens, Bridgeford continues. You just don't have to deal with me anymore, so that could be a positive, in fact. Thank you for the question. If there are no other questions, I want to sincerely thank my friends at McKonly Asbury and Morgan Lewis for not only the support, but the friendship and the collaboration. We're going to continue to have fun on big ideas. thank all of you, those of you in the audience who have known us over the years, who have supported us, who have protected us, who have been through a lot of our ups and downs. Bridgeford, I mean, the trajectory and the position and the state of the union at Bridgeford is very strong. We're not stopping at Philadelphia, although we're also not done celebrating Philadelphia. Next move is New York City. They have a rep office there to spread the word of modern trust law, and then also Northern California to continue our California expansion. So thank you all for taking so much time. I'm sorry if we went late, and I hope there's still some food left over. But we're in a really dynamic space right now, and that's the quote I want to leave with, and also Bono's quote. Remember, uncertainty is a guiding light. Don't let all the uncertainty create some sort of a paralyzed position. I think it's a call to action, so let's make it happen for our clients. So thank you all.